Many times after a divorce has occurred and the trial court has already made all of the decisions necessary about child support and time sharing and parenting plans, circumstances of life change and one spouse has a need to move from the jurisdiction. Perhaps it's because of a job change. Perhaps it's because that spouse has family members in another jurisdiction that can help that spouse with child care. But in any event, a need to relocate more than 50 miles from the courthouse arises. How does a parent today handle that situation? The Florida legislature has created a statutory framework that allows for the efficient relocation of children if the other spouse doesn't object. Quite simply, if you're the spouse willing and wanting to relocate, you file a petition with the court outlining where you want to go, when you want to move, and other criteria established by statute to assure the court that the children will be well taken care of in the other location and that the children will still be able to have a meaningful relationship with the non-moving spouse. If that petition is filed and there is no objection to it filed by the other spouse, then the court has a strong presumption in favor of that relocation, and 90 times out of 100, maybe 95 times out of 100, the relocation is going to be permitted without any further litigation. Of course, in those circumstances where the other spouse objects to the relocation, and assuming the other spouse timely objects to the relocation, then there's a trial where many of the same factors used by the court in determining original time sharing are again considered by the court. Things such as, will the moving parent have a better income in the new location? That better income can help the child have a better lifestyle, more educational opportunities. Are there family members in the other location that can help with childcare? All factors that are looked upon favorably by the court when thinking about relocation. But just as important to the court is the impact on the non-moving spouse, because the courts will want to assure everybody that if there is a relocation, the non-moving spouse does not lose out on the benefit of contact with his or her child or children. It is vitally important to the court that even though we live in a mobile society and everybody acknowledges that moving is sometimes required, that the non-moving spouse not have his or her visitation or his or her relationship more adversely impacted by that move than has to be. Relocation is a very sensitive area of the law. It involves massive emotions, many times factors that weren't present in the original trial.